This is an eviction information session for tenants in Maine with Pine Tree Legal Assistance. My name is Maddie Thompson-Crossman. You can hear this presentation live every Tuesday morning at 9 a.m. at ptla.org/FED. You can reach Pine Tree Legal Assistance for questions about your own specific case at 774-8211, Mondays 12 to 2:30, Tuesdays 9 to 11:30, or Thursdays 9 to 11:30. Who is Pine Tree Legal Assistance? We are Maine's largest civil legal services provider. We have offices in Portland, Lewiston, Augusta, Bangor, Machias, and Presque Isle. We help people in all parts of the state of Maine. We hope to help tenants know and defend their legal rights. We can't help everyone who contacts us for assistance, but we have a website, ptla.org, where you may be able to find information to help you handle your own case. What will we cover today? We are going to talk about the eviction process, known as the FED process. Landlords have to go through the court process to evict a tenant. And if your landlord tries to force you out without going to court, that is illegal and you can call the police. And that includes changing the locks, shutting off your utilities, physically confronting you, moving your personal belongings out of your living space. All of these things are unlawful if your landlord does them without getting a court order first. The kind of notice your landlord has to give you depends on whether you have a lease, and it depends on why they want to evict you. If you have a lease, your landlord has to give you the notice that is written in your lease. If your lease expired less than 7 days ago, your landlord doesn't have to give you a new notice before starting a court case to evict you. If you have no lease, you are what's called a tenant at will. There are very specific laws about how your landlord has to give you notice in order to end your tenancy. If you're causing damage to the residents or danger to other people, they can also give you a 7-day notice. If it's for no particular reason, they can give you a 30-day notice. The next part of the eviction process happens in court. If you receive paperwork saying you have a court date, you must go, because if you don't appear for a court hearing, you will be ordered evicted. There are 3 phases of what happens in court. There is a docket call when the judge makes sure that everyone is present. There is an opportunity for mediation, either talking to your landlord directly or using a mediator. And there may be a hearing. Here are some tips for appearing in court during COVID. Some court dates are being conducted by phone or by Zoom. If your court date is by phone, the court may send you a notice with call information, including a meeting number and password. You should make sure to call from a place where you have good reception. And once you call the call number, enter the meeting number and password when you're prompted, and be aware of when you are muted and when you are not. If your court date is by Zoom, the court will send you a notice with a Zoom link or a meeting number and password. You need internet access, and you may need to download Zoom software in order to participate. Start logging in early to give yourself time to practice. You can go to zoom.us, select join, and enter the meeting number and password. If your court date is in person, you should be prepared for a security screening at the courthouse. If you have symptoms or if you've been exposed to COVID, you should contact the court before your court date. Masks are now optional in all courthouses. If you can't get to court when you have a scheduled court date, there are a few things you can do. If it's because of technology, if your hearing is by Zoom and you don't have a computer or a phone, you can try to find a phone that you can use, or you can bring the court a letter asking for permission to appear in person. If it's because of COVID and you have particular COVID risks, you can mail or ask a friend to bring the court a letter asking for permission to have your hearing by phone or video, and you want to provide as much documentation as possible. If it's because the time or date doesn't work, you can bring the court a letter asking for a new date and explain why. The court will usually not give you a new date. There are 3 possible outcomes in an eviction case in court. You may come to an agreement that works for you and your landlord. You might win your case, which means that you can stay, or you might lose your case, which means you have 9 days to move out. There will be a 7-day waiting period after the landlord wins the case. After that, the landlord can get the writ of possession. And once you're served with that, you'll have 48 hours to move out. Mediation. So you may want to settle your case by talking to your landlord and coming to an agreement. You can agree on a move-out date, or you can agree to a payment plan or some other conditions in order to stay in your home. If you and your landlord come to an agreement, you can ask the court to continue or postpone the case in order to have more time to make the agreement happen, or you can let a judgment enter that gives you time to make the agreement happen. If you settle, Put your agreement in writing and submit it to the court. You can ask for help. There may be a mediator in court who can help you write out the terms of the agreement. If you can't settle your case, if you can't come to an agreement with your landlord, remember that no one can force you or your landlord to settle. And if you can't reach an agreement, there will be a court hearing. If you win your hearing, you stay in your unit. If you lose, you move out within 9 days. We're going to talk about some eviction defenses that you may be able to use at a hearing. These are some common eviction defenses. One is bad service. You'll remember that your landlord has to have you served with a notice to quit before beginning the court date. If they didn't properly serve you or they didn't serve you at all, you can move for the eviction case to be dismissed. The notice may not be long enough. You'll remember that if you're a tenant at will and your landlord wants to evict you for no cause, they have to give you a 30-day notice. If you're a tenant at will and your landlord gave you a 20-day notice, that notice is not long enough, and you could move for that eviction to be dismissed. If the notice has not expired, if you're a tenant at will and your landlord served you with a 30-day notice, and on the 20th day, your landlord served you with a summons and started a court case, that notice has not expired, and you could move that that eviction be dismissed. If the person evicting you doesn't own the building, only your landlord or an attorney representing the landlord can file the eviction case in court. And so if the eviction case is filed by a property manager, for instance, you may have a defense to the eviction. If the notice is not true, if your landlord is evicting you for breaking down the front door and you did not break down the front door and you can present some evidence that you didn't do it, you may have a defense to the eviction. If your landlord is retaliating, your landlord has an obligation to provide you with a safe and decent place to live. And if they haven't done that, and you have reported them to a code enforcement officer, or you've written them a letter saying you need them to fix things, and they immediately have you served with an eviction notice, you may have a defense to the eviction. If the eviction is related to domestic violence, that can be a defense to the eviction. A landlord cannot evict you for being a survivor of domestic violence. If your landlord is illegally discriminating, your landlord can't evict you on the basis of certain characteristics. So if you think that your landlord is trying to evict you because of any of the following characteristics, that would be unlawful. Those are race or color, sex, sexual orientation or gender identity, religion, ancestry, national origin, family status, or disability. All of these eviction defenses that we just talked about can be extremely complicated to raise on your own. And if you have questions about any of them, please contact Pine Tree for assistance. I'll talk a little bit more about evictions and disabilities. If you're being evicted because of your disability, you might be able to ask for a reasonable accommodation. You'll need a letter from your doctor or a medical provider. Your disability has to be linked to the reason you're being evicted, and you have to show that the accommodation you're asking for will make the problem less likely to happen again. So for instance, if I have a cognitive disability that makes it hard for me to remember to pay rent on time, I may be able to get a doctor's note saying that I have this disability and that I am in the process of getting a representative payee who can manage my money and would make me less likely to pay rent late in the future if I'm being evicted for paying rent late. Again, this is complicated, and we encourage you to contact Pine Tree if you have questions. I'll talk a little bit about special rules about subsidized housing. If you live in subsidized housing or you have a voucher, your landlord has to follow special rules before you can be evicted. So that means Section 8 vouchers, BRAP vouchers, any kind of housing where part of your rent is paid by the government. So that means any kind of housing where your rent is dependent on your income. If you're evicted from subsidized housing, you risk losing your subsidy. You may not be able to get it back. So call Pine Tree for help or specific information about your type of housing. There used to be some special rules about COVID-19 and evictions. Early in the pandemic, there was a rule that created special defenses for certain kinds of evictions that was known as the eviction moratorium. But on August 26th of last year, the Supreme Court struck down that moratorium. There is no ban on evictions. Evictions can take place and are taking place right now. Another important thing is that you can be ordered evicted in the winter. There is a myth that there's a law that means tenants can't be evicted in the winter, but there is no such law. Tenants can be evicted in the winter. Some tips for getting ready for a hearing. You should always be prepared to go to hearing when you have a court date. You may not be able to settle your case with your landlord, even if you hope to. So things to get ready are any documents you want the court to see with copies for you and for your landlord, any witnesses that you hope to put on the stand for your case should come with you to court. You want to review your story, make sure you remember everything correctly, and you want to confirm with the court about how you should appear by phone or by video or in person. During the hearing, the landlord will go first. They'll present their case about why they should be able to evict you, and then you'll have the opportunity to present your case. And the rules of evidence apply. And even if you're not a lawyer, you have to follow the rules of evidence, which means you should make sure that everything you plan to talk about is relevant to why your landlord wants to evict you and why you think they shouldn't be able to evict you. And also, another important rule is hearsay, which means that if you want to present evidence of something, it has to be presented by a witness who saw it happen with their own eyes. You can read more about that on our page on the website, Tips for Going to Court. And remember that during the hearing, you need to focus on the facts related to the reason for the eviction and what it is that you disagree with your landlord about. What happens after the hearing? If you win, the case is dismissed, you're still a tenant, you get to go home. Your landlord can still try to evict you, but they have to start the court process all over again from the beginning. What if you lose? A judgment will enter against you. 7 days later, the landlord can get the writ of possession. A sheriff then serves the writ on you. And once you're served with the writ, you have 48 hours to move out before your landlord can have law enforcement remove you. There are some resources that may help you as a tenant. One is emergency rental assistance. You can get up to 12 units of rental assistance if you're eligible. It can help you pay for rent and electric bills. It can help you pay for a hotel if you're experiencing homelessness. To be eligible, you have to be at 50% of your area's median income and have experienced financial hardship during the pandemic and be having trouble paying rent or other bills. You can apply online at mainhousing.org/ERA, or you can call your local community action agency. There are some other resources that may help you maintain your income and meet your needs. General assistance through your local town office or city hall. You can apply for food stamps or TANF if you have children through your local Department of Health and Human Services office. If you're a veteran, you can contact Preble Street Veteran Services. You can apply for subsidized housing by contacting your local housing authority. The wait lists for subsidized housing are long, but you might as well get on the list now. There's more information on all of this available at ptla.org. You may also want to look at the court system website, courts.maine.gov. for up-to-date information on court processes. And you can always call Pine Tree Legal Assistance for help. Our call center hours are Mondays 12 to 2:30, Tuesdays 9 to 11:30, and Thursdays 9 to 11:30. You can call any of our local office numbers during those times. You can also join this info session live any Tuesday at 9 a.m. at ptla.org/FED.